their defense is, we're not selling this as a drug. And our response is, yes, you are. So what information can we discover that shows that that's what they know it's being used for and that's what they intend it's being used for?
In today's episode of Lawsuit Review, I speak to Johnny Simon, the attorney who represented the estate of Marissa Polite, a young woman who was struck and killed by a driver high on whippets, essentially an unregulated drug formerly known as nitrous oxide. Johnny sued not only the driver, but the distributor and the retail provider of the whippets under a product defect theory, obtaining a $745 million verdict. The purpose of Lawsuit Review is to learn from the best lawyers in the country. This is a podcast made for plaintiff and referral lawyers and sponsored by my firm, Kherkher Garcia. The only thing we ask is that if you're a lawyer who has a case similar to the one discussed in today's video, please consider joint venturing it with our guest. Their contact information is included in the research summary. But if you have another type of case that involves catastrophic injury or high-stakes litigation, please consider joint venturing your case with Kherkher Garcia. We pride ourselves on maximizing case values by routinely taking cases to trial and winning. Our reputation at the courthouse has allowed our firm to routinely secure top dollar settlements. Additionally, we joint venture cases on a 50-50 basis with our referring counsel and front all case expenses. We have paid tens of millions of dollars in referral fees over just the past few years. But most importantly, we aren't afraid to recommend another law firm if we feel that somebody else is a better fit for your case. So if you have a case that you are considering joint venturing, click the link in the description to contact us and we'll respond as soon as possible. Thank you. The name of the case is Karen Chaplin and Jason Polite. Did I say that right? Polite versus United Brand Products Design Development and Marketing Incorporated, DBA United Brands Corporation et al. Johnny, how did you get involved in this case?
So I had handled a case against this company, United Brands, before, and during that case, I was suing on behalf of someone who's addicted to their nitrous, and they were obviously saying we're not aware of any dangers or harms, and the plaintiff's misusing our product. Then during a deposition, a news article came out about a woman being killed by someone huffing nitrous. And the lawyer I know who was handling that case called me because he found my case. And he was like, hey, do you think there's an angle here? And I was like, absolutely. They're selling to these head shops, and this is the foreseeable consequence of that conduct.
Okay, so when
it was referred to me,
pre-lawsuit being filed.
Yes.
So when you filed the lawsuit, you didn't even need additional discovery to include this product design, this product defect element of the case.
That's interesting. So I had just resolved my past case against him, which was called the Snyder case, or Jacob Snyder. And I offered to the other lawyer, hey, we already have the world of documents from this past case. I know what exists out there. Do you just want to stipulate that I can use the past information that I have? And he wouldn't stipulate. He said, no, the cases are different. So I did have to reserve and re-engage in discovery. And it ended up being a really positive thing for me because I got a lot more information than I had in the past case.
Can you tell us about the information you uncovered?
Yeah. So, the toughest part of the case is, proving foreseeability, proving that they, their defense is, we're not selling this as a drug. And our response is, yes, you are. So what information can we discover that shows that that's what they know it's being used for and that's what they intend it's being used for? So we asked for things like sales numbers, one of these little cartridges, and I can get one for you. This isn't the brand at issue, but this is a nitrous oxide charger, right? One of these makes 16 ounces of whipped cream. Okay. They come in packs of 24, 50, 100, 600. And so if you're buying 100 nitrous oxide chargers, or even 50, you're making a whole lot of homemade whipped cream. Um, so their sales numbers, we wanted to get their sales numbers to every store or head shop that they sold to in Missouri. We wanted to get customer lists showing that, are they selling to Starbucks? Are they selling to the groovy psychedelic shop, or, other ridiculous names? And, the amount of charges that they're selling on an annual basis, their emails, their internal emails about the risks of selling to smoke shops, about people allegedly misusing or inhaling this product. So we were able to put together a set of documents, of which, I've been practicing. This will be my 9th year, and I've never seen anything like this. Just horrible, horrible, kind of no harm is happening and just selling anyway.
Sure.
Prior lawsuits against the company. They have been sued a couple times, once by myself, once by a lawyer out in California who had a really good idea, didn't execute it very well, but tried to be like a private attorney general, suing all the shops to kind of shut them down. But they ignored those. I mean, they were getting emails from parents saying, "Hey, I found one of these in my kid's car, bought it at a smoke shop. What do you want me? I need to return it to you. You shouldn't be doing this." And you'd see internal responses, Tom, like that just said, like, "Ha ha, let us help him. He wants us to help parent his bad kid." And I'm like, my goodness.
Right. If you had to estimate how much of their sales were coming from places like smoke shops and maybe nefarious entities rather than the legitimate cooks and bakers of the world who
So
need
we
nitrous.
actually, so I went out and found via LinkedIn, actually, a former employee of United Brands who managed their warehouse. And his name was Matthew Choppy, or Choppy, Choppi. And he was a witness. His deposition was played at trial. And, he was the warehouse guy. So they import the nitrous from abroad, and then they redistribute it throughout the country using, third-party logistics companies and stuff like that. And he was willing to give a deposition. He had been terminated. I never really knew why, but I think it's because he was reporting that, we shouldn't be selling this stuff. And he gave an estimate that some 75% of their sales were to smoke shops and head shops. And we had a list of their customers, an A to Z list. And, we had asked for every smoke shop or head shop you've ever sold to. And they kind of shot themselves in the foot, and they said, well, that's too burdensome. We'll give you all of our customers. And I mean, you go through it and it adds up. It's about 75%, if not more, in my opinion.
So you get this evidence. I'm sure the entire time the corporate defendant's theory of the case is you can't blame us for the acts of a bad kid who he shouldn't have been doing this while driving. It's totally the driver of the vehicle's fault. Correct?
Yes.
How do you overcome that when you go to trial? What's your strategy? What's your, what is your theme? How do you defeat that argument?
So, and I thought about this a lot, and as lawyers, we have, we're presented with how do we frame things, how do we present things. But, in this case, there were so many moral forces at play, and it kind of was how do you frame it? And I kind of looked at it logically as, look, what is the root problem of what happened? The root problem is this kid had access to this easy access at a head shop for this purpose. I mean, that's
Right.
That's the problem. So, ladies and gentlemen, if you want to get rid of the problem, it's like mowing grass, right? Or taking out weeds. If you cut the weed out on the top, it's going to come back, even stronger than it was.
Right.
But if you attack the root of the problem, you can stop it. And so that was kind of the frame. The other thing that really helped was, Mr. Geiger, who was the guy who, the defendant who actually did the driving and huffing. He was a really good, nice kid. Never had any prior problems with anything. Kind of was the vulnerable kid that these companies prey on, who needs a quick upper or a mood booster. He had dropped out of school and was living with his parents, who were nice folks. And, he did smoke a little marijuana, but, whatever. And he got into nitrous. And that was his drug of choice.
And other than the nitrous being in the store, is there another product defect element of it to just how it was designed? Was the bottle designed to be easily consumable by people who are driving?
This is really it's one of the things that they're going to raise in their appeal is, that is, to prove a product defect, you have to show in Missouri that a product is in an unreasonably dangerous condition when put to a reasonably anticipated use. Okay, we're a second restatement state. We don't need to show an alternative design. Um, you know, it was more of a, if you're selling it as an inhalant, it is defective, right? So it comes down to the reason that they're selling it. And if they're selling it as an inhalant, if the jury decides that, then everyone agrees it's defective. Because how can they not? It's not. So there were a lot of helpful analogies that I used with my expert in Vordaer. One of the things that we did was say, everyone's aware of Tide Pods, right? Tide Pods, the Tide Pod Challenge. You and I are young enough to know what that is. I had to explain to my old man who tried the case with me, that kids were eating Tide Pods.
Yeah.
But it's like, okay, look, no one would have people would have a problem with suing Procter and Gamble if someone eats one of their Tide Pods. But what if they're selling it at candy stores? Does that change your mind? It's like, oh, of course, right? What if they're selling it in toy stores? You'd have a little bit of a problem with it. So it's like, we didn't point to a particular, like, this is designed badly or this is too easy to access. My last case, I had allegations like that, but in this case, it was more, it turns on the use and the intended use. And, I don't, if anyone looks at the evidence and the facts that we've gathered and thinks that they're selling it for its proper use, I mean, people were scoffing on the jury when they're like, it's a culinary product. It's like, okay, then why are you selling it to a head shop that's selling 6-foot bongs and fake urine and, one hitters and all kinds of drug paraphernalia?
Right. And at the drug shop, could they buy single packets of it, or how was it sold?
So it's sold. No, they sold it in boxes. So they sold it in 24 packs and 50 packs, and I think they had some 100 packs, but they had them. One of the things that I'm a firm believer that you cannot really evaluate the result of a case unless you were in the courtroom, right? Because you never know what happens. You're not there to evaluate the testimony. And the smoke shop had said under oath that they had stopped selling the stuff by the time this kid had bought it. Said he bought it from the store. But in my last case, I had sent a private investigator, just fortuitously, I didn't know about this case, to this particular store to buy nitrous the month before this happened. So in the deposition of the corporate rep of the store, he's like, yep, raising his right hand. We stopped selling this stuff in 2019. He couldn't have bought it from us. Didn't buy it from us. And I'm like, so what you're telling all of us is that under oath, you did not have this product on your shelf in 2020. And he's like, yep. And then I played this video showing it's right on their shelf. And he's like, is it like, yeah, I don't know. Yeah, I guess we were selling it. Like, but other than it being on the shelf, I mean, it's how they were promoting it and marketing it and selling it. So they had it on the shelf kind of in the back, and they have like code words that you can't say. You can't say, do you have any crackers? Because a cracker is like a cylindrical device that pops it open, but it's only for inhalation use. So if you go in and say, do you have any crackers? They're like, sorry, bro, we can't sell that to you today. Like, come back and, we'll see what we can do, but no crackers,
Right.
or they call them cream chargers and not whippets.
Gotcha. And so ultimately, what percentage of fault was placed on the manufacturer, on the smoke shop owner, and the driver?
So, and that was super interesting. So I suggested 70%, 15%, and 15%. Because I said, look, everyone here knows they're the problem. This company is the problem. You can cut these people out, but they're at the end of the day, the smoke shop's just a single location smoke shop. The kid's just a kid. I think if we talk about fault, 70%, and the jury came back with 70% fault on the distributor, on United Brands, and
Wow.
then 20% fault on the smoke shop, and 10% fault on the kid.
Can you break down the damages?
Yeah, so in Missouri, we have compensatory damages, and we submitted on punitive damages, and the trial was bifurcated. So we asked for $250 million into compensatory damages, and the jury found $20 million to compensate the parents for the loss of their daughter, who didn't have any kids, and we didn't submit a lost wage claim or anything like that. The second element of damages were punitive or aggravating circumstances. They're a little bit different, but similar concept. And for aggravating circumstances damages, they found 0 against the kid, 25 million against the smoke shop, and 700 million against the distributor.
Wow. And what's the current status of this case?
Post-trial motions are going to be heard soon. So they're telling me that they're going to pursue an appeal, and we're looking forward to fighting to hold the verdict.
Have you noticed, are any of these defendants making any changes, or if I went to a smoke shop today, could I buy a nitrous oxide?
That's one of the things that we did at trial that I really think was the nail in the coffin. I mean, it was just this is it for people, because their lawyer stood up in opening and said, we stopped selling this stuff after we got sued by Mr. Simon. He handled another case against us, and so we learned our lesson. And when he said that, I was like, okay. And I hired a private investigator to go buy as much product as they could of their brand from any smoke shop in Missouri. And at the end of the trial, in rebuttal, I put on, with one of their employees, we really established what you're telling the jury is that we would not be able to get in our car today and go buy these. That's what you're telling us. Then they could start having, they're like, well, not exactly. Because what they ended up doing is they created like a middleman in between them. Like they just created like a in-state distributor who then distributes. So it's same stuff. And in rebuttal argument, we wheeled in 20,000 nitrous oxide chargers that we had bought in 2 days, and dumped them out on the floor. Just like,
what a scene.
And people were just like, okay,
wow.
But, as they say, as I learned, in trials, if you lie, you die,
Totally. Wow. That's incredible. That is incredible. Johnny, thank you so much for taking the time. I think everybody will find this case extremely interesting. If anybody has a case similar to this and they want to reach out to your firm, where can they contact you? What's your contact information?
Yeah, sure. So our website is www.simonlawpc.com. You can submit an intake, or you can call our number at 314-241-2929.
All right. Thank you so much.
Thanks, Tom. I appreciate it, man.
Yep. All right. I just